Not support this bill.
Honourable David Parker.
Mr Speaker, I think it's regretful at some of the misrepresentations of the legislation by the last Speaker. With respect to her, she should know better. Her irresponsible conduct is one of the things that undermines public confidence in our important democratic institutions. Mr Speaker, the Labor Party is already on record. In fact, I'm on record in the first reading of this bill when I said that I too was dissatisfied with some of the police conduct in respect to the Tūhoe raids. They were wrong. I still think there is a need for us to scrutinise whether it was right to have black-suited men with high-powered rifles crawling over school buses. I thought that was an overreaction by the state.
Order. I'm sure the member is aware of something that is sub judice, but I just want the member to talk in principle without referring to the level of specifics he's getting into. Honourable David Parker.
Well, Mr Speaker, I was referring to things that were on the news and I wasn't held up in the first reading of this debate. I don't need to take it any further, but that, with respect, I'm quite entitled to say what I've said. Mr Speaker, but for the member of the Maori Party to then go on and suggest that what this was doing was making the unlawful lawful, that's not correct. What's actually being done here is to give a prospective power legally, as this Parliament is entitled to do. Can I take issue also something with what Mr Locke said? Now, Mr Locke, I have considerable respect for you, and I wish you well in your retirement. But to use the example of Europe as if this is some reason that New Zealand law enforcement officers ought not to have a prospective power of surveillance appropriately prescribed is plain wrong. I would be surprised if there is one country in Europe where the police or the security agency doesn't have a power of covert surveillance, albeit with judicial, what's that? With trespass, getting a warrant, going on someone's house and actually, or in a business premises and putting in a video camera to surveil people who are alleged to be conducting very serious crimes. I'm sure that those powers are held in just about every European country. So to suggest that the European experience is a reason why New Zealand ought not to have appropriately prescribed powers for our police and security agency is wrong. Can I refer to something that the attorney said? He sort of took a flick at my colleague Charles Chauvel. I would have to give credit to Charles Chauvel for having actually put the welly in and actually done more work on this bill than anyone else in this House did. And that's giving due respect to the attention that it was paid by other minor parties, including Rodney Hyde. It was Charles Chauvel who stayed up at 3 a.m. to draft a supplementary order paper that could have listed powers for the police appropriately prescribed, requiring a warrant, having a minimum level of seriousness of offence and prescribing a list of agencies to which the legislation applied. I do not accept what the attorney said, that there was an attempt, an impossible attempt to lift powers from the search and surveillance bill. Yes, it is true that Sir Geoffrey Palmer says that the search and surveillance powers in respect of search and surveillance bill powers couldn't be lifted holus bolus because there are things like training regimes and reporting regimes. Well, we didn't have to lift those provisions. PCO had no other drafting on its books. Parliament's about to rise. There was no other legislation required to be drafted. This was the most important constitutional issue to arise, and in a matter of days they could have done the appropriate drafting of the legislation, which was quite simple and which Charles Chauvel had done the bulk of anyway, to have to get a warrant, has to be from a judge, minimum level of seriousness of offending before you get it, and a list of the agencies to which it applied. And if that list was short and it missed someone out, well, those people could do it through the police if it was a serious matter. So, Mr Chairman, this legislation is, Speaker, this legislation is not as good as it could have been, is better than it was, does leave to the court the exercise of their discretion of illegally obtained evidence, and I trust them to exercise that discretion wisely. We've given that discretion so that they do have the ability to exercise it if it is necessary. Mr Speaker, I'm not going to say anything else. I do think it's unfortunate that we haven't passed the search and surveillance bill. I do have a suspicion that the reason it hasn't been passed is that there were 3 conditions that Labor raised. One, we need to constrain the powers that are currently too broad for the Serious Fraud Office, who have at times abused those powers. Given that we're giving examination order powers under the Search and Surveillance Bill, which do override the right to silence, that should be more prescribed, and we do need to be clearer about press freedoms. I have a suspicion that the intention of the government is to ignore those 3 reasonable conditions and try and whack it through after the election, and I invite the media to watch this space in respect of that, because I can see no other reason why we haven't had a response to the letter that I sent on behalf of the Labor Party a year ago. With those reservations, Mr Speaker, I am happy to record that the Labor Party is supporting this bill.
Honourable Rodney.
Thank you, Mr Speaker. Just a short one.